Namaste, Shriman. Thank you so much for accepting our request, first of all, to give your time and be part of this initiative which Kathmandu School of Law Review has started to take interview of the professors and experts of legal field to motivate students, especially law students of Kathmandu School of Law, to see the journey of many experts in the field and take motivation from them. I hope you are doing well.
Yes, thank you, Prajwol, for coming over to me and for your interest in my journey and my work. Thank you.
Thank you, Shriman. So, after more than 3 decades of distinguished service in the judiciary, you have recently retired from the Supreme Court. So, how is your retirement life going on, Shriman?
It's going fine in the sense that I'm trying to resettle and relocate myself to the connection that I have had on the academic side of my life.
That's very nice, Shriman. So let's start your early career life or your life, your history, let's say, about your career. So has there been any key moments that you reminiscence during your upbringing that inspired you to join the field of law? So is there any events in your life, in your upbringing, on your school or high school or anywhere?
In fact, by and large, it has been accidental for me to come to the legal field. But when I recollect, I am born and brought up in a family of political dissidents. When I came to see the world, I became aware about my surrounding. My father was not at home. He was in political exile. But when he came back after amnesty in '69, for the first time I saw my father. And slowly and gradually, democracy, rule of law, and people's right, all these things started being discussed at our home. But parents and my elder brothers, I'm the youngest one in the family, so they were keen to enroll me in science. And I didn't know what to do. But when I started my studies at the intermediate level in science, I then slowly realized I'm not for science. My faculty was more philosophical. So slowly and gradually I started developing interest in law, partly because of the family inspiration and partly because I felt science was not good for me. That's how I landed up in the study of law. And plus the family environment and concern for democracy and rule of law. These are the factors.
Well, that's interesting, Shriman. So you have had an interdisciplinary academic journey. If we see, you have studied law, you have also studied political science and also English literature.
Oh yes.
So how has your diverse education shaped your understanding of law and legal philosophy?
I had some interest in English literature, but even though I studied at a vernacular school in Pokhara, compared to my peers, my English was fairly good. Maybe because of that, I had an interest in English literature. But after graduating in law, what did I study in the English literature and political science? Is because of the fact I was so keen to go for further studies, and since I was a cadre of the judiciary and I was waiting for the Colombo Plan Fellowship, which was trickling down during those days, one quota for the judiciary in a year, that kind of thing was there. So meanwhile I thought I should improve myself. So I studied political science and English literature. given the fact that English was so necessary for enhancing your career. This was also the motivation.
Okay. So, Shriman, I think you have also been part of international fellowships. For example, you have been part of Hubert Humphrey Fellowship and also Alexander von Humboldt Fellowship. So, how important is international exposure for the law fraternity in Nepal? What do you think about this?
Okay, before I come to Hubert Humphrey and Humboldt Fellowship, let me tell you my journey regarding my LLM and doctoral studies in India. After 12 years of my work at the Supreme Court, I got a chance to study in India. National Law School that time was a growing institution. And as a Colombo Plan Fellow, I was offered a place in Delhi University also, but I chose to go to Bangalore. And I now, in retrospect, I feel that I made a right decision. It was a very vibrant organization, and later Indians started rating their institution, and it has stood fast. And after having work experience of 12 years and my exposure in English literature and political science, that cumulatively contributed to my studies at National Law School. I stood first in the LLM, first class first, and I got the highest score in their history. So that was a real boost up, academic boost up for me. I came back and started working at the Kathmandu District Court. And I came to know about this Hubert Humphrey Fellowship by my senior colleague, Dr. Tripathi, and I applied. And I got in my first attempt, I got a chance to go to MIT. That was 2002 and 3, one academic year at MIT. It was a really good experience for me. Even though I had some initial hesitation to go to MIT, I went to Fulbright Commission and argued with Mike Gill, who was then the chief of the Fulbright Commission in Nepal. I told him I want to go to law school, but he insisted that it was a time for me to branch out. And he later revealed that he himself was a lawyer, and if he was given that opportunity, he would have really enjoyed going to MIT. That convinced me and went to MIT. And MIT and Harvard have a credit transfer facility. They are just 2 stations apart. So, besides taking mandatory courses as a Hubert Humphrey Fellow at MIT, I could go and audit classes at Harvard Law School. And I did that. I took 4 or 5 courses at Harvard Law School, 1 course at Fletcher School of Law and Diplomacy. Because I had to go to Fletcher School because that the schedule at Harvard Law School on law and development conflicted with my schedule at MIT. So as an escape, I went to Fletcher and took that course. So very new subjects, because Boston is considered to be academic capital of USA.
Yes.
So after getting that golden opportunity, I didn't want to stall out. Even though this fellowship gives a lot of flexibility, whatever you want to do, you can do that. Besides taking some mandatory courses, so I had plenty of time, and I got exposure in very new areas of law, such as terrorism, development, corruption, environmental negotiation, and multi-party negotiation, those type of courses which are not really taught in South Asia. So that helped me a lot, and I was sometime thinking that I should do another PhD in USA. People, when they go to those kind of institutions, have that kind of ambition. So I was working on my proposal. But my professor at MIT told me, when I approached him for a reference, he told me that it's a waste of time to do another PhD and spend 4 or 5 years. And he told me that it was a waste of time. Instead, he asked me to go for postdoc. That took me to Max Planck Institute, Heidelberg. So I applied for Humbl Fellowship and I got a chance to go to Max Planck Institute of Comparative and Law and International Law. That's a wonderful, world-class institution in Germany. That was in 2005 and 6. And you see, the beauty of Humboldt Fellowship is that once you are a Humboldtian, you are a Humboldtian for life. So after spending around 14 months in 2005, I came back, and then they give you 3 to 5 months grant to pursue your studies in areas where there is logical progression of your work. So I went there in 2008, 2010, 2012 and 2018, taking up different areas of work. First time, that was a longer duration, I worked on protection of Himalayan biodiversity, which later came out in the form of a book. And so that took me 1 full year plus 3 months. The book came out in 10. On 12, when I went there again in 12, Nepal was experimenting with constitution. So I started research on the shape of the on the structure of the judiciary that Nepal should have. And this is how I have been going to Max Planck for studies.
And this Humboldt is only for postdoc, or how does it work?
Humboldt is for postdoc.
Okay.
So if you want to go to Germany for masters, one has to apply as they call it DAAD fellowship, DAAD.
Yeah.
And for doctoral studies, generally you apply to the university and professors. You reach out to the professors, and if your interest and their interests align, they will give you fellowship. Some 800-900 euro, and that will be sufficient, more than sufficient in Germany. Humboldt is basically postdoc fellowship.
Okay, Srimant, so now moving towards your career. Now, during your initial phase as a bench officer at Judiciary, you have shared in many other interviews as well that you had experience working with prominent chief justices of that time. So how do you view their approaches to resolving legal disputes, and how have these changed over time during your tenure as a judge?
Very interesting. You see, when you asked me this question, I remember working with Chief Justice Anand Mohan Bhattarai. He was a wonderful person, very learned, very hardworking, more than that. And he had a unique style of making people work. He was very cool, creative. He used to jot down points in his notebook and ask us to elaborate. The idea, and before he did that, as bench officer, we were required to make a brief summary presentation of the case. So that required a lot of hard work, but that was so enjoying. And I worked with him for around 6-7 years. Then he was succeeded by Dhanendra Bahadur Singh. Their style was different. Dharendra Bahadur Singh was a very sharp person. And he used to write short sentences, very pointed sentences. As bench officer, you have to mold yourself according to the vision and working style of the chief justices or judges. So, because you will be writing decision not for you, for instance, for me, I'll be writing decision for them.
Yeah.
So, I need to know what kind of sentences they prefer, what are the usual expressions they would like to have, and how do they approach the case and how do they decide. So that gave me a lot of opportunity to develop my legal writing and legal thinking. So in total I worked for 8 years as a bench officer. During my time, it was the longest period for any bench officer to work for that long. And that helped me a lot down the line when I started working as a judge.
And how do you see, what changes do you see now from the approaches those chief justices had and the justices, as you were also justice, what difference do you see?
You see,
judgments.
as a judge, looking at cases, the regular cases, it is not that much different. But when you look at the legal framework or constitutional framework, your role is different. For instance, during those days, independence of the judiciary was a bit shaky, and power of judicial review was not given to the court. And then, the security of tenure was also not very firm. Even though when I started working at the Supreme Court, no judge was sacked, but there was a history. Because Justice Prakash Bahadur Singh was sacked, was asked to resign, and he resigned. And Justice Biswanath Upadhyay was transferred to Law Commission. Those kind of things had happened, and then so the influence of those kind of ugly things was there at the court. But now, after 1990, when the framework of the Constitution we embarked on our democratic path and independence of the judiciary was secured, then that made a very positive impact in terms of the role and responsibility of the judges. And I should say that our responsibility got expanded as final interpreter of the Constitution and custodian of the Constitution. The role changed.
So, what are the major challenges or constraints did you and your contemporary generation face during the initial years as a young legal professional, like as a young bench officer? So, and being based on your experience, if you can give any words of wisdom for the young cohort of legal professionals or law students who are going to pursue their legal career in the future.
I really welcome young talents to the judiciary, because the constitutional provision regarding judgeship, especially at the district court level, they are good. They are good, and now good officials have gotten through the district judges examination, and that's the number is going to increase. So if a person becomes a judge at an age of say early 30s, he will have a time of 30 to 35 years to work as a judge. I became a judge, a district judge, when I was 34. So, and I see that if you become a judge at that age, nobody will stop you to come to the Supreme Court, because you have such a long tenure. And the charm of working as a judge is you have full autonomy. Full autonomy. If you do not listen to external influences, nobody can harm you. Nobody can harm you. And a judge, as a judge, if you are truthful to the kind of service you are assigned to, then you can enjoy. And compared to my time, the facilities have increased. And even though, if you look beyond your borders and compare your emolument and benefit with judges in India or Pakistan, then is very less. But also you have to look at the local situation. And if you want to live a Spartan life, then it's okay. It's okay. There will not be too much, but it will not be too little either. So the thing is, you have full autonomy to use your creativity and mold yourself in the way you would like to grow as a judge. This is the beauty of the system. And there are ample opportunity of growing yourself, getting elevated to the High Court and Supreme Court.
So you have been involved in numerous landmark cases, Shriman. So what has been the most challenging aspect of serving in the judiciary for such an extended period? And which of your rulings do you believe will have the most lasting impact on Nepal's legal system?
I don't know. I leave it to the law students. And I'm happy to tell you that some of my decisions are closely studied and reviewed by law students. That makes me really happy. I feel that I am surviving in the memory of young talents. Every generation has talents. It's not that our generation was talented and this generation is not so talented. Every generation has talent. And given also the fact that you are now more equipped with the boons of science and technology, you are more access to legal resources. So your evaluation and analysis will tell me about the work that I have done, and which will have a lasting impact. I don't know, and I leave it to you.
Thank you so much. Sure. Another question that I have is, you have cited philosophers in your writings, in your judgments, like Amartya Sen and Derrida in your work. So how do you integrate their ideas into your legal reasoning, particularly in social justice and human rights cases?
You see, I started following Jacques Derrida during my study of English literature. When I was doing Masters in English literature, there was a course called Literary Theory, where you have to study structuralism, post-structuralism, reader response theory. I don't know that's still there or not, but during my time, literary theory was philosophy of literature, and which later became relevant when I started studying jurisprudence at the Masters. So Jacques Derrida was referred to, and Derrida is also remembered during the study of jurisprudence, especially in areas of critical legal studies movement. So he talks about deconstruction and bottom-up approach. About Amartya Sen, in India, when we are supposed to study law, society and development, the nuances of development economics were referred to. There, and so the contribution made by Amartya Sen and Mobabul Haq, he is from Pakistan. They are the people who made a real impact in the study of development. So the calorie intake approach of poverty was challenged, and it should be 89 or 90. UNDP started measuring development through the lens these two professors propagated. Later, his theory of justice, development as freedoms, these books really influenced me to look at law from a different lens. So Amartya Sen, and when I was a student, it was during that time he got Nobel Prize in Economics. So another attraction was there, and besides he was from India, and sometime he taught at Delhi School of Economics. Those factors, his close grip of the Indian situation, which has so much salience in the study of the Nepali situation, attracted me towards him.
So, reflecting on your tenure as a judge, you have contributed to all subject matters of law. So, however, your scholarly writings and landmark judgments depict your strong inclination towards environmental justice. So, what sparked your deep interest in environmental law, particularly within the context of Nepal's unique geographical and ecological challenges?
Very interesting. This is a very interesting question. I'll take you back to the law school. When I started my studies at National Law School, we are enrolled, the masters that we were offered was LLM in business law. And this is generally the course. This is generally the course. But then environmental law was a upcoming area, and I got attracted to it, but this law had an urban bias. Like during those days when people used to study environmental law, they used to talk about vehicular pollution, noise pollution, water pollution, all those things. But Nepal had a very rural landscape. It doesn't mean that Nepal didn't have environmental challenges. Nepal had environmental challenges. For instance, I used to remember my mothers and sisters. There's so much in-house pollution because they used to cook food inside the main building. This was, and with firewood, that was the prevalent practice in Nepali rural areas. So huge in-house pollution was there, and then people used to die of waterborne diseases. I remember my near and dears dying with say dysentery. Like if you were given some preventive medicine, or you could have saved life. This kind of problems were there, and then positively forestry was coming. Community forestry was coming in a big way. So then there were issues concerning the construction of high dams. The Khanal project was studied. It was planned to be a high dam project, and during those days, India had a lot of controversies on high dams. Those kind of things attracted me to environmental law, and now there are more problems and challenges. We are placed at a very a very challenging environment that drew me to the protection of Himalayan biodiversity and protection of the Himalayan system. This is how I got attracted to environmental law, and my exposure of this subject enabled to me light to have an in-depth study of the challenges and also write on these areas.
So, Nepal has set landmark precedents in these environmental issues, such as excavation in the Churya Hills, which was drafted by you, and where you referred it as ecocide. So, how do you see Nepal's role evolving on the global stage regarding environmental law and climate change?
Thank you for referring the Chure case. Chure case is so closely related to the life and livelihood of the Nepali people. We have, under the circumstances, we have tried our best to save Chure. But now, from a different angle, when you look at issues, many issues which, say, a decade back, you used to think as local issues, have become regional or global. For instance, forest was considered to be a local issue. It is no more a local issue. Because of climate change, there is so much impact on forest fire, and then the greenhouse gases coming out of the forest fire, that have made the issue global. I'm happy to note that the International Court of Justice is now considering a matter and trying to issue advisory opinion on climate justice, and I'm so happy to know that Nepali youths like you and your friends, you have taken initiative to file a written submission, make a written submission to the World Court. It is a very laudatory effort that you have done. I'm so impressed by you and your colleague. I had occasion to look at here the note that you had prepared, and since I know that the oral arguments will be taken up sometime in December, through you, I request Nepal government to make timely decision on Nepal's participation and raise the voice in World Court about Nepal. Unless you do that, mountains and Himalayan system, they do not get priority. Look, for example, at the Rio conference. Either you take Biodiversity Convention or the Framework Convention on Climate Change or the Statement of Forest or Rio Declaration, mountain is not mentioned. Not a single word is mentioned about mountain. It is only in Agenda 21, Chapter 30. It mentions about mountain. Mountain are in the periphery of the environmental discourse and the discourse on climate justice and climate change. So Nepal has to put this agenda to the World Forum. It is a really good opportunity and you should miss it. I am hopeful that the Nepal government will take a timely decision on this. And there are to tell you very frankly, there are very few international lawyers. And I really bank on young lawyers like you who have taken lead on this subject. And age should not be a consideration. Rather, exposure and energy and commitment to work should be the consideration when deciding who should represent Nepal at the ICJ. So wish you good luck. And Nepal should not miss this opportunity. That's what I feel.
Thank you so much, Rana, for your kind words. I would also like to mention about the role Nepal is playing in the COP negotiations. Like if you are following there also, Nepal is trying to raise the issue of mountains. As you mentioned, the mountains issues have not been given enough priority in the international platform. So how do you see that, like Nepal's role in other platforms, global platforms, where they can play major role by raising the issue of mountains?
Last year, Nepal really played a really good role in the Doha conference, and before that, the Secretary General of Nepal visited Nepal, so he could see by himself what is happening in the Nepali mountain. If I remember him correctly, he said it is gross injustice committed to the Nepali people and the Nepali mountains and Nepali environment. This was, in essence, his message. And in Doha, Nepal, Doha also he could come to the program organized by Nepal. So this is a very laudatory work that Nepal has done. Nepal should continue to project Nepal and Himalaya to this kind of forum, so that, you see, they do not just pay lip service to the environmental degradation happening in the mountains, but something tangible also comes in the form of compensation or reparation, or maybe in the form of the contribution we have made by saving our forest. So these are recognized and Nepal gets paid back by the whole community. This is what I expect.
Yeah. I would also like to add to this question, Shriman. So young lawyers like me or some others who are thinking of pursuing their career in environmental law. So what suggestions do you have for us? Like, because whenever we talk about environmental issues or climate change, it's more like people say it's more of environment science issue, or it's of climate change experts who can speak. Yeah, lawyers are not the right person to speak on this. So what do you think like lawyers can do in environmental law areas?
The Asia Foundation had organized a regional dialogue on climate change and climate justice. I participated in the dialogue, where I said, when you look at the situation whether it is biodiversity laws or climate change, the discourse is no doubt first led by scientists. Then came policymakers, lawyers, especially at a time when you were required to draft treaties, right? These scientific postulates were framed in the form of legal mandate and do's and don'ts that were part of the declarations and conventions. It is only when around 2002 judges started becoming part of this discourse. Especially, I remember the Johannesburg conference, where judges for the first time participated. And then now, it is more, judges and lawyers are listened more. Because if you, scientist, whether you are a scientist or a lawyer or a policymaker, you work under the constitutional framework of your respective country. And when it comes to implementation of international law, it is the domestic terrain where it is implemented. And there you require the role of lawyers and judges. And also taking at the situation a little differently. It is long before the international environmental community recognized environmental rights as human rights. It is the domestic courts which extrapolated right to life to include right to environment. So it is in the 80s itself the Indian courts and in the 90s Nepali courts started extrapolating right to life to include a healthy environment and so on and so forth. Right to health, right to education, environmental education, and environmental rule of law. All those things came from the domestic court. And it is in the last decade only, thanks to the work of John Knox and David Ward, they started hammering at the OHCHR level. And first as consultant, then later as rapporteurs. They started writing on linking human right and environment. This is how the process started at the United Nations, and now we have this declaration on right to human right and environment. And it's the role of lawyers. Here you see the role of lawyers. And young lawyers like you, if you wish to earn money, maybe this is not the right discipline that you should embark on. But if you have to make academic contribution or contribution for saving your people and your environment, this is one area where you can make a lot of things happen in the positive direction. So from that perspective, I really wish you good luck, and I encourage young lawyers to study environmental law, climate change law, and related subjects.
Thank you, Shriman. So now, moving to another question. So over time, you can see our courts have been facing newer and more complex legal disputes. For example, issues of private international law, transnational organized crime, climate justice. So your experiences have made you proficient in various areas of legal disputes. How would you suggest law aspirants, legal professionals and judges to better comprehend and resolve these legal disputes related to new areas?
First, the expanse and dimensions of the problem. As I mentioned already, whatever you thought to be a local problem is no more a local problem. Universalization of challenges. That requires you to study international law. And secondly, the compartmentalization of international law and domestic law, the wall of separation, is slowly and gradually crumbling down. Whether you are a monist state or a dualist state, you have to refer to international law. And international law, including the climate change law and human rights law, because of first the human rights law and then environmental law, is having an impact. Is percolating down to the national legal regime, and because of the fact that we have such young constitution and a growing legal system which emphasizes on the recognized principles of law and justice, it takes us to comparative law and environmental law, and also the rights that are incorporated in our constitution. Right to a clean and healthy environment. It's not just clean; it is healthy. In order to be healthy, you need to take up many considerations into cognizance. So it requires you not just to look into facts, also look into the legal norms. So the intermingling of national law and international law will be a good tool to address the environmental and climate change challenges.
So what about other areas, Shriman? For example, private international law, which has been now in our civil code, it has been there is.
This is also growing. This is also growing. This is a growing area because of the people's movement. Now there's a huge Nepali diaspora living abroad, keeping their roots in Nepal. A lot of issues are coming in the court on adoption, custody of child, property right, and recognition of marriage, those kind of things. So when I was a law student, private international law was an optional subject. I didn't study private international law. When later I became a judge, I came to know the importance of private international law, and it is growing. It's growing. Given the fact that we are a part of the global community, our lawyers should be abreast of the development taking place in private international law, and especially science and technology, the internet law, and other things are also required to be taken for studies and research.
Now I have your last question, Shriman. So, given your extensive experience both within Nepal's judiciary and on international stages, what key reforms are essential for advancing the judiciary and legal education in Nepal?
More transparency, promoting good governance when it comes to the work of judiciary and other legal institutions. Good governance is a big challenge in the country. Wherever you see there are challenges, whether it is a local government or a state government or federal government, you see a lot of challenges pertaining to good governance. And so, in order to address those things, the court has to keep its house in order. We have started the planning process in the judiciary, and of late, this differentiated case management is being introduced in the court. It did like 5 or 10 years for this new initiative to show its true color. But there is a direction. The judiciary has taken up a direction of reform, but the leaders in the judiciary have to pursue it collectively. It's not just the responsibility of the Chief Justice. It is the responsibility of all the judges of the Supreme Court. So if you move in a planned way and introspect the work that you have done, and also look at the challenges and aspiration of the people, all those things will give you a direction. So the process has started. And your another question was on the legal studies, right? Nepal, in recent time, in the last 10 or 15 years or 20 years, because of the private initiatives, the establishment of schools like Kathmandu Law School, Kathmandu School of Law, and other schools has produced young talents, very well qualified, and I'm happy to see them in the courts as lawyers and court officials. And I think we'll have a better situation in another 5 or 10 years' time. We'll have more young talents coming to the judiciary as judges and officers, and also as law professors. And also because of the fact that there's so much competition at the international level, good legal education is a precondition for young graduates to prosper at the international plane. So I think the leaders in legal education, the professors, have seen these challenges clearly and develop curricula and develop strategy to address the challenges. I'm so hopeful that situation will be much better in the coming years.
So I'd just like to add one recent development which has taken place. I don't know if you are updated with that or not. One of the university has recently given affiliation to 15 colleges to start BA LLB course right now. 15 colleges, and TU has also given to 3 colleges. So there will be more than 30 law schools right now after in some years, or it has already started, 30 law schools in Nepal. So what do you see that development, whether it is a good development or it...
Globally, legal education is seen as a special type of education. It's not a general education. In the 60s and 70s, especially in India, legal studies was considered to be part of the liberal education program. Lot of law colleges were opened up. Here also, like appearing LLBs or BA LLB privately as a private student was also possible. But now with the opening of the BA LLB program, we have moved from taking legal studies as a general education program to special study program. So I don't have to say anything about more educational institutions being opened up, but I'm more concerned about the quality of legal education. This world is so competitive. Unless you maintain good quality and just graduation in law will not give you bread and butter. So this factor has to be taken into consideration, and I hope that those people, persons responsible for granting permit to law schools or those involved in legal education take this factor into consideration. And this said, I wish them good luck.
So another question I had last, I would say, is what unique practices and perspectives from Nepal's judiciary could serve as valuable contributions to the international legal fraternity? What do you think Nepal can contribute, Nepal's judiciary can contribute in the international legal fraternity?
Two things come to my mind when you said this. First is the use of our own language in the judicial discourse. See, India for a long time continued with English, and now they are now embarking on local languages, right? Decisions being translated into local languages and proceedings being opened in local languages at lower courts. We already have in place our own language as the medium of discourse. I understand there is a flip side of it. We are less studied internationally, but be that as it may, but we are serving our people more closely than the courts in other countries, other jurisdictions. Second is in terms of access to justice. The network of courts in Nepal is much better than the network of courts in our neighborhood. So 77 districts, 77 courts, and the neat tier of the court, all the cases going to the district court, then one step up into the high court, and the high courts and their branches spread out throughout the country, and then a second appeal at the Supreme Court. This is a neat structure of the judiciary. So these two factors really fascinate me and compared to the working of the judiciaries in South Asia. And another factor that comes to my mind is the flexibility that we have adopted. We are an evolving system. We know we are an evolving system. We attach importance to comparative law. Our reference to comparative law helped us to look into similar situation, how the challenges are being addressed. So this makes us as an evolving system more flexible to adapt, which is so important for a mountainous country like Nepal. So maybe this could also be a message or a point to look into when one is interested in the Nepal legal system.
Thank you so much, Shriman. Thank you so much for your time. But before we end, if you have any message, this journal will be published for law students, especially readers are law students and law professors or researchers. So if you have any message for law students or professors or researchers who will be reading this interview, so if you have any last message for them.
My message to the Kathmandu School of Law and the students associated, faculties and students associated with Kathmandu Law School is all appreciation that I have in mind as a pioneering legal institution. Establishing a legal institution by a very few dedicated people is a very challenging task. And Kathmandu Law School has made a name not just locally, also internationally, regionally and internationally. It's because of the dedication of the faculty member, Professor Yuvraj Sangrola, Geeta ji, Professor Geeta Sangrola, a lot of faculty members associated with Kathmandu School of Law. And also the very bright students produced by Kathmandu Law School. They have received fellowship in very noted universities. Many of them have, some of them have returned to Nepal, some of them are doing so good abroad. And dissemination of legal knowledge and in-depth research that Kathmandu Law School conducts in different areas of law and justice is very laudatory. And I congratulate Kathmandu Law School community, its teachers and students. You have a very bright future and make best use of your time at Kathmandu Law School. And you will come with flying colors, and your future is very bright. Thank you.
Thank you so much, Shriman, for it. Okay, Shriman, so with regards to Nepal's judiciary, you also talked about many cases. So right now there is already increase in there are so many cases pending in the Supreme Court. But I wanted to ask you about the increase in public interest litigation in the courts. Though there are provision of filing public interest litigation in High Court, but majority of the cases are going to the Supreme Court. So how do you see this, like the increase in the cases, especially through public interest litigation?
It's a very interesting question. I have a mixed feeling about PIL. Given the constitutional framework that we have in place, we cannot really ignore PIL petitions. And also because of the fact that public interest petitions bring a lot of issues of public concerns, which public attaches high importance. The PIL route makes the court socially relevant. Had there been no provision for public interest petitions, many constitutional issues that the court has resolved would not have come to the Supreme Court. From that point of view, I do not want to discourage PIL petition, but this said, there is a rush, PIL rush. Today, for instance, the government makes a decision, and maybe a controversial decision. The next day, at least 10 or 15 people will be filing PIL petition. This is without research, without any in-depth studies. And this is, I would prefer that they take a pause, do some research, and also make a collective effort instead of running solo. And in Vincent Pokhrel, the Supreme Court said that before coming to the Supreme Court, you go to the concerned ministry or the decision-making authority, ask for the decision, make a request to the concerned authorities to correct by themselves. Then only if you fail in that effort, then only come to the Supreme Court. But that is not really having any influence on filing of these cases. So, but some lawyers filing PIL make deep studies and come to the court. In the past, WLD did this kind of effort. First, they brought the discriminatory laws, did in-depth research on discriminatory laws, and then they started filing petitions. This is one method of working. And there are some cases on environmental issues also. A case is pending in the Supreme Court where the petitioners have studied the excavation work activities being taken up in all major rivers. And lawyers from all 7 provinces with photographs, data, and other facts and figures have filed a petition. These kind of petitions, if these kind of petitions are filed, that helps the court in resolving the issue. PIL is a collaborative process. Regarding another aspect that you mentioned in the question, instead of filing to the High Court, to the Supreme Court, I cannot say for sure why do they do that. Maybe because of the fact that Supreme Court is the final authority, instead of taking a staggered process, they want to come to the final authority, or they are impressed by the work that Supreme Court has done in the past. Maybe because of that. But it is better to use High Court instead of bringing all the cases to the Supreme Court.
Thank you so much.
On text.
So another question I had, Shriman, is regarding the development of technology. So you talked about your experience as a bench officer and then as a judge. So right now the technology has developed a lot. There is new innovations, there is artificial intelligence and everything. So how do you see this? How do you compare your time and this time with regards to technology, and how do you think it will be helpful, or what it will be with regards to judiciary?
It helps a lot. It helps a lot. I remember when I was a young officer, we only had the hard copies of the Nepal Khanal. So you had to refer the cases all by yourself, and there was no easy retrieval system. Now you have the retrieval system in place. I myself remember my research, which I did at the National Law School. So around 1400 cases being surveyed in 7 days, which would not have been possible had there been no facility of online research. These kind of things are helping a lot. Now the Supreme Court has installed LexisNexis. I believe, and I'm so hopeful that the digital divide will be very soon bridged. For a long time, we tried to establish that. Thanks to the family members of Justice Silu, who helped the Supreme Court establish that search engine in the Supreme Court. And otherwise also, universities have access to e-books and online resources. You yourself, you did such wonderful work in making the submission to the ICJ. I can see the hard work that you did looking at different materials. It's the boon of the science and technology. So life has become much easier these days, and then to basically to produce quality of work, very quality work. The situation is more positive. That's what I think.
Thank you so much.